depending on who is going to do what. If you are interested in what we call a retire secure consultation, you can sign up for that now. I've already kind of given a little pitch for that before, particularly, by the way, if you have a chronically ill or disabled beneficiary, but also you like the idea of a master plan, you like the idea of having some integration between wills, trust, estate, your wills, your trust, your after-tax dollars, your IRA dollars. You like having a good Roth IRA conversion plan. You like having money invested in low-cost index funds. You should consider our asset under management, where, again, we do the financial master plan that we would otherwise charge $10,000 or $15,000 for. We have this wonderful set of money managers. You'll be hearing from two of them at 1 o'clock, all for the combined fee of 1% or less. I would encourage you to sign up for that consultation now. All right. So, and I'm going to have to go through this a little bit quickly because I'm a little bit behind, but what is the best choice of wills and trusts and IRAs and after-tax dollars, et cetera, for the, what I would call, leave it to Beaver family? All right. Well, it's a problem because what are some of the typical choices? Surviving spouse, kids equally, and trust for grandkids. So, for example, what would be, and we call that this typically the simple I love you will. I leave everything to you, my spouse. I leave everything to you, my spouse. Something happens both of us, it goes to our kids equally. Something happens to one of our kids, the money that would have gone to that predeceased child would go to a trust for the benefit of the grandchildren. All right. But what's one of the problems in estate planning? Is that really the best will? Well, remember we talked a little bit about who gets what? Maybe that's not going to be the best law. What's the law going to be like when you die? There is a huge difference in our planning now than our planning for even before 2020, when the Secure Act. Now, in our case, we knew that this was coming and we were planning for this years ahead. But if we hadn't, would have had massive changes to many of our estate planning documents. We don't know who's going to die first. Sometimes we always assume the husband's going to die first because he might be older and he's a male, and we males don't live as long as you women. But sometimes it's the woman who dies first. We don't know how much money is going to be there. We don't know the needs of the survivors. We don't know what the tax situations are going to be. We don't know what state both you are going to die in, and we don't know what state your kids are going to be. We don't know where they're going to be a resident. And there's all these different implications. And we do thousands of projections. That is part of our running the number process. How much of a Roth IRA, how much of a gift, should you get insurance, can you afford a second house, blah, 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 blah. But we've done thousands of them. And where your kids are going to be. And I humbly admit that every one of them has been wrong. Something other than what we thought was going to happen happened. Now, we still do them, and they're still extremely valuable and much better than nothing. But here's my point. If you try to predict the future and you base your estate plan based on that and something that you didn't expect happen, you might end up in a far from optimal estate plan. So what do we typically want? Well, we want to protect both spouses while we're alive. We want to protect the surviving spouses. We want to cut taxes, leave the most money to your family. And if that's what you want, type a Y. Yep, that's what we want. We want to protect our spouse, tax-free rollover, unlimited marital deduction. The spouse, by the way, is one of the exceptions to the Secure Act. So the spouse can stretch the IRA over her life and actually the life of beneficiary deemed 10 years younger. That was the joint life expectancy of the spouse and somebody deemed 10 years younger. There is no required minimum distributions for a Roth IRA. Sometimes we want the children, if they are minors, that there's an exception for minors that I don't have time to get into. Even the adult children might be in a lower income tax bracket. We might want to have what we call the Schwartz maximizer, named after Matt Schwartz, who he will sometimes have a certain portion of the money go to the children to avoid having the survivor pay anything more than, say, for example, 24%. Maybe the child needs some money. There are certainly circumstances when we want grandkids to have it. Maybe the kids don't need the money. Maybe the kids have creditors themselves. So again, most people would typically want spouse, then kids, then grandkids. And I did ask you to put a Y in the chat. Those are I love you wills. But let me suggest a better solution. The better solution might be, and this is going to be typically for what we call the Leave It to Beaver children or Leave It to Beaver families, which is don't decide now, but let your survivor decide after you're gone. So how would that work? Well, by the way, so it protects your spouse. It allows the possibility of money going to your kids, even at the first death. It allows money to possibly go to your grandkids at the first death. And the solution, are you ready for this? Drum roll. It is Lange's Cascading Beneficiary Plan, which, by the way, has become quite famous since I came up with it. And I've been doing these since the mid-90s. We've saved people hundreds of thousands of dollars, sometimes $1 million or more. So here's how the cascade works. We start by naming the surviving spouse. Then the contingent beneficiary is the children. And then the second contingent beneficiary is a trust for each set of grandchildren. All right. Well, gee, how is that different from the plain old I love you will? Because we are going to introduce and include the concept of disclaimers, which says that no one can force you to take a bequest. But if you don't want it, the money goes next in line, and the survivor has 9 months to decide. So if you say, I leave the money to my spouse, but if my spouse doesn't want it, then that money will go to my kids equally. So you leave your spouse a choice. If you want it, it's yours, end of story. If you want, you can disclaim all of it, in which case it goes to the children equally, end of story. Or perhaps more frequently, you keep part of it and you choose to disclaim part of it. But that decision isn't made now when you're drafting the documents. That decision is made within 9 months after the first death. And it's really a system, all right, because typically you want this for all your assets. You want it for your IRAs, your after-tax, your Roth IRAs, et cetera, et cetera, et cetera. And we started doing this in the 90s. We had a peer-reviewed article that included this in 98. Jane Bryan Quinn loved it and put it in Newsweek in 2001. It's been in the Wall Street Journal multiple times. It's been in 3 of our best-selling books with testimonials from a lot of big shots. Our most recent book, Beating the New Death Tax, or even new book that has the bonus of the book for professors. I've taught this to thousands of attorneys, CPAs, financial advisors, tens of thousands of consumers. And if you count books and digital outreach, hundreds of thousands of people. The solution and the books have been endorsed by Charles Schwab and Jane Bryan Quinn and Ed Slott and Burton Malkiel, Larry King, Roger Ibbotson, probably 60 more. Again, we've drafted maybe 2,800 of these. Most of these have disclaimer elements in them. And it has resulted in protection or overprotection of the surviving spouse, and sometimes savings of hundreds of thousands or even over $1 million. So what is the estate planning home run? Well, the ideal trust, estate plan, long-term multiple Roth IRA conversion, ultimate Social Security, running the numbers, taking into consideration the Secure Act, as well as investments typically with low-cost enhanced index funds. And if you can get all that for 1% or less, that is something to seriously consider to take advantage and have the Retire Secure consultation with me. So quick wrap up, and I know I'm pushing it. I'm at, I guess, 12:01 right now, and I have a few minutes to go. But what we've talked about: revocable trust to avoid probate, trust for minors, trusts as beneficiaries of IRAs or retirement plans, spendthrift trusts, special needs trust, and trust for chronically ill beneficiaries. And we covered Lange's Cascading Beneficiary plan, which I believe is the best estate plan for married couples that have that traditional family unit that I am calling the Leave It to Beaver family. So what are some of the ways that I could potentially help you? Well, we could develop your financial master plan, which it is unique. It focuses on you. I just had a discussion with the director of my marketing plan, of the marketing department yesterday, and he said it would be great if you could really further define exactly how these financial master plans work and have it really uniform. And I said, you can't do that because everybody's a snowflake. Everybody has a different situation. Even if you had two people with identical money, identical tax bracket, identical tax returns, you might have people with significantly different values, and they will end up with two significantly different plans. So it really is very individually focused. It takes razor sharp estate attorneys and financial advisors, it takes razor sharp estate attorneys to figure out what is the best plan. And then, particularly if you're not a Pennsylvania resident, to help you get that plan. And then razor sharp CPAs to run the numbers. It starts, by the way, with a discussion with me. And if I think you're a good candidate and you want to work with me, I draft this very long memo and I, in effect, do an outline of some of my ideas for both your estate plan and your retirement plan and your Roth IRA conversions and your gifting, et cetera, et cetera, et cetera. And then, assuming that you are interested, then you have a discussion with our money manager. And if you decide to go ahead, you have a great money manager using what we think are the best set of low-cost and enhanced index funds on the planet, who has his own 40-step process, who you're going to be hearing from at 1 o'clock, named Adam Yofan, who works for Buckingham Strategic Wealth. That they are a $50 billion company, which is a nice size. They're big enough that they can have a lot of options for their clients, but not, like a really big Merrill Lynch that is, I don't want to say anything bad about any of the big wirehouses. They're wonderful institutions. But anyway, I believe that the combination of me, again, looking at you in the digital eye, the combination of me and them, all working on your behalf for 1% or less, I genuinely believe is the best deal out there. We are doing these financial master plans on a fee-for-service basis at this point. The fee is somewhere between $10,000 and $15,000, usually 10. On the other hand, and again, this isn't hype, we're just going to run out of capacity, and it's going to take us a while to increase capacity. So I'm not even sure that we can even offer that after today. If you're interested, still apply. We'll see if there is room, depending on how things look and how many of the people that I talk to. But very honestly, I ended up with 16 consultations yesterday, and I will likely end up with roughly that many or more. And most of the people do end up being clients one way or the other, or at least want to be. And it's not like we're this 500 person firm. We have, 5 CPAs and 3 estate attorneys. So we have, and at this point, everything's coming through me. So we genuinely have limited capacity. But it does focus on your situation, does come up with the best long-term strategy. We talk about how much money you can safely spend. The legal portion of this master plan or assets under management, I can't emphasize how important that is, because I hate to say it, but at least by our standards, most wills, trusts, and IRA beneficiaries that we see prepared by other attorneys, whether it's Pennsylvania or outside Pennsylvania, they are nowhere near optimal, and they should be changed. And it's not necessarily because they are dated. Most of them were no good on day one. I hate to say that, but that is truly the way we feel about it. And part of our job, or maybe a job that we are taking on is, again, if you're a Pennsylvania resident, and by the way, it's not included, but we can charge you to prepare all those documents. Or if you're not a Pennsylvania resident, we're not even allowed to charge you because we're not allowed to practice law outside of Pennsylvania, but that doesn't mean that we can't make some suggestions and to some extent give you feedback, or even, depending on what state you live in, be able to refer you to an estate attorney who will get this right. But, you also want to get your Roth IRAs right. You want to get your gifts right. This financial master plan and the advantage of assets under management is then it's updated every single year. So that is part of our review process.